Now, last week, Don Lemon fought against a protective order that the government had requested from the judge. Now, the government was about to produce initial discovery material and wanted the protective order in place to prevent potential misuse of the material. I mentioned last week that the proposed protective order looked typical to me, and either 32 or 33 out of 38 defendants agreed to abide by the proposed protective order, including Nakima Levy Armstrong, Chantel Allen, and William Kelly, aka Doe Oak Farmer. But the Journalist-defendants, they refused to abide by the protective order. Don Lemon, Georgia Fort, and Shane Bowman. Now, that seemed ominous to me, given that the proposed protective order sought to protect the personal information of victims and witnesses in the case, all of whom are churchgoers who were subjected to a takeover-style attack against City's Church in Minneapolis. Now, I theorized last week that the journalist-defendants all could be planning to write best-selling books about the case, at a minimum, and for that reason could be planning to store and make copies of the discovery material to use later on. Now, the protective order prohibits storing and making copies. The discovery material can be used in the case and any appeal, and for no other purpose. Now, this week, the journalists filed their oppositions. Now, one of their major objections turned out to be that the protective order requires redaction of all names and identifying information of victims and witnesses in any court filing. Now, either that or the filing must be made under seal. Now, the government says the victims and witnesses have been subjected to doxing and harassment already. So, the journalist-defendants say, well, no objection to redacting social security numbers, birth dates, addresses, etc., but they say that the witness and victim names should be unredacted and place names should be unredacted because the names and images of the churchgoers are already on video footage that was circulated online. The journalist-defendants neglect to mention, however, that names and faces aren't connected in the video footage necessarily, and, more to the point, the names and faces aren't already in the court filings. Now, the government's discovery material apparently includes hours and hours of interviews with victims and witnesses, and obviously gives away specific information about the churchgoers that must remain under seal. Now, their lives shouldn't be publicly exposed just because they're providing information in a criminal case. Now, it's absurd for the journalist-defendants to say there's no threat of future doxing, given that there's been past doxing, and given that the defendants themselves gained entry to the church through deceit, shut down the worship service, chased the churchgoers out, called them Nazis in the house of the devil, then proceeded to make court filing after court filing, declaring that all they were doing was peacefully protesting. Now, it's an outrageous mockery, and to their credit, at least 32 out of 38 defendants consented to the protective order. The activist defendants all consented, except for Amelia Hansa, and this week, Monique Collars-Doty seems to have revoked her consent. Now, she filed in opposition this week, objecting to the use of the word victims to describe the churchgoers. She says they were not victimized by her conduct, and a filing like that just makes her look bad, okay? The judge seems to have ignored it, which I'll get to later. Now, back to the journalist-defendants. In their oppositions, they bizarrely assert that the public has the right to know at least the names of victims and witnesses and names of places that might be referenced in the court filings. But that would give away location information of specific witnesses and victims in the case. And why would the public have the right to know their names and where they work? Aren't those two pieces of information dangerous in the wrong hands? Now, the public doesn't have the right to know that stuff. Defendants can put on a defense without exposing the personal lives of the witnesses against them before trial. And a huge amount of the video recorded interviews with witnesses and victims won't be admissible at trial, so the public will never have the right to that material. We only have the right to access material in court filings and in a public trial, if not under seal, and that's it. Now, that's the constitutional standard for a speedy and public trial. The Constitution doesn't say speedy and public discovery. A lot of discovery in this case won't be admissible at trial at all under the rules of evidence. Now, the journalist defendants also objected to the protective order requiring that the discovery material be limited to use by members of the legal defense team. Now, this is very standard in a protective order. The defendants here, in contrast, the journalist defendants, wanted the authority to share the discovery material with family members, which would be so dangerous. Family members. Don Lemon's third cousin, for example, could become accomplices, or third cousin might sell the information to MS Now. Family members have no real interest in preserving the confidentiality of victims and witnesses who could convict their family members and put them in prison. Journalists have no interest in that either. Now, for example, I've been following another case on this channel. A search warrant executed on the residence of a Washington Post reporter. The Washington Post intervened and asserts that journalists allegedly have the right to keep unauthorized and leaked classified information on their personal devices for privacy reasons. Oh, the irony, privacy reasons. And if the government wants its classified information back, allegedly only the Washington Post has the right to go through the devices to isolate classified information from unclassified. Although, the Washington Post has no idea what the classified information even consists of. And could they never be hacked? For example, that's how John Bolton, former NSA, got indicted. He kept classified information on his home computer for purposes of writing a best-selling memoir. Then he got hacked by Iran and reported the hack. Now, if he hadn't reported it, the government still would have traced it back to him, given what the classified information was. Now, that's how they traced the Pentagon leak to the Washington Post reporter. Now, back to Don Lemon's third cousin. He could sell the government's discovery material to MS Now, as I mentioned. Now, this week, the fourth journalist, Michael Walker Butte, who's Lemon's camera guy. Now, he was quiet last week, but this week he refused to consent to the government's request for a protective order as well, and he asked the court to add his name to Don Lemon's opposition. Well, this week, all of the journalist defendants, Don Lemon and friends, those who were fighting against the government's protective order, suffered a defeat. The judge granted the government its protective order without a lot of comment after the journalist defendants filed their oppositions, which revealed their impermissible and atypical reasons for objecting to such a non-controversial protective order that has such socially beneficial reasons behind it. The objections reveal that the journalist defendants in the case seem to have even less consideration for the rights of the churchgoers than the activist defendants in the case, people like Nakima Levy Armstrong, Chantel Allen, and Dowoke Farmer, all of whom consented to the protective order. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.